Good morning, everyone. I'm Avinash Pandey. I'm a third year student at NMIMS Kirit P. Mehta School of Law, Mumbai. And today in this video, I'll be talking about the Section 11 of the Arbitration and the Conciliation Act 1996, which basically talks about the appointment of arbitrator in a dispute. And I'll also be covering a case law that is Uttarakhand purv sainik Nigam versus National Coal Limited. So this was a case law that was based on this section. So basically, Section 11 of the Arbitration and Conciliation Act talks about the appointment of arbitrators for a dispute resolution that has between two parties. So Section 11 basically allows the parties to choose arbitrators of their own, and in if certain cases the both the parties are not able to come to a mutual conclusion, both the parties can appoint an arbitrator of their own, and within the 30 days of both the arbitrators being appointed, they have to have a third party, which will be a neutral arbitrator, which will be appointed in the case as well, and and he will also pass the judgment or the arbitral reward. So Section 11 also has some clauses that need to be taken care of while appointment of arbitrators. So the first is that the nationality of the arbitrator is not important unless both the parties have already decided upon. So basically, if both the parties have decided upon a particular nationality for the arbitrator, they cannot choose an arbitrator that is not of that nationality. And as mentioned earlier, the second clause talks about the parties' right for appointing an arbitrator of their own choice. And in case both the parties cannot appoint an arbitrator, the Supreme Court and the High Court also have the power to designate arbitration institutions, which are basically designated under the Arbitration Council of India, and it is mentioned under Section 43 of the Arbitration and Conciliation Act. And for the appointment of arbitrator, either by the parties or by the Supreme Court or the High Court, the limit is only 30 days. So, talking about the case law, that is Uttarakhand Purv Sainik Kalyan Nigam Limited, Nigam versus Northern Cement Limited. So, this was a case law wherein both the parties had an agreement and they had contracted for some construction work, and after few days there were problems that were arising between the parties, and the respondent had refused to pay the amount which was decided upon them in the contract. And following this, the petitioner had filed a legal notice for arbitration, but this legal notice was ignored by the respondent. After that, moving forward with the legal notice, the petitioner had also sent a notice regarding the arbitrator that he had chosen for the case, and he had also requested the respondents to choose an arbitrator so that they can move forward with the case. But the respondents had not responded to any of the messages or the legal notices that were sent by the petitioner. So under Section 11 of the Arbitration and Conciliation Act, he had filed a petition in the High Court. So the High Court had initially denied the appeal, and the petitioner was not happy with the decision that was passed by the High Court. So he appealed so he filed a special writ and appealed this judgment in the Supreme Court. So the Supreme Court straight away had set aside the judgment passed by the High Court, and after this, they had also mentioned that uh, after appearance of both the parties, they had mutually agreed upon an arbitrator for which the grounds were similar, which were according to the case. So the arbitrator chosen in this case was according to the needs and wants of the case and the facts of the case. And after that, the liberty of venue was given to the parties, and if they were not able to decide, the court was of the view that they could decide as well. And they were also of the view that any charge and any of the miscellaneous expenses that was to arise for this case law, and for this arbitration appeal was to be divided in half by both the parties. So that means if any party is having to pay the fees, it will not be a one-sided expense. Both the parties will have to divide the charges 50-50, and hence this case was one of the initial cases for the section 11 of arbitration, the section 11, which is the appointment of arbitrator under Arbitration and Conciliation Act 1996. Thank you.